Hello friends, welcome to lecture number 4 of Sale of Goods Act in CA Foundation lecture series sponsored by Shri Jayendra Rank Zone. I am your mentor Shekhar Gehlot. Now we'll proceed with conditions and warranties of sale of goods. Now what are conditions and warranties? At the time of selling goods, a seller usually make certain settlements, certain statements. Okay, when we go to buy something, okay, we are always given some statements like the motor will work for 2 years, and the battery will not become dysfunctional for 1 year. The charger is having a warranty of 6 years or 6 months, and the car's engine will run up to 2 lakh kilometers, and so on. Okay, so many claims or statements or toll claims are made by sellers to lure into buyers to sell their own product. Okay, to lure in buyers for selling their product. These are the claims made by sellers at different point of times. Now, with a view to induce the intending buyer to purchase the goods. Okay, now they are making representations with a view to induce. Induce whom? He want to induce the intending buyer, a buyer who's showing some interest in purchasing the product. In They want to induce him into finally purchasing the product. Okay, such representations are generally about the nature and quality of goods. Okay, they are usually about nature and quality of goods and about their fitness for buyer's purpose. Fitness also a kind of quality. Okay, so about nature and quality or fitness, these claims are made by sellers. When these statements or representation do not form a part of the contract of sale. Okay, when these statements and representations do not form part of the sale of contract, like let us say I buy a car, say Honda City. The company says car will not stop till 3 lakh kilometers. It means that car can clock 3 lakh kilometers. Its engine will not become dysfunctional before 3 lakh kilometers. Okay, that is the minimum. They are saying that at least 3 lakh kilometers the car shall cover with this engine set. Okay, but they when these statements do not form part of a contract, they are not
It's three
relevant
o'clock.
and have no legal effects on the contract. But they did not give it in writing. But they did not give it in writing. Okay, neither it is part of contract. Okay, neither it is part of contract. Then these statements are a mere statement made by a seller and they do not become part of your conditions or warranties. They do not have any legal implication at all. These are just castles of sand. Okay, but tables turn when these statements form part of the contract. When now Honda City, when the company Honda gives me in writing that this car will run 3 lakh kilometers. Okay, now it gets its own legal implications, and I have certain legal rights now in this situation if the car stops before clocking 3 lakh kilometers. A representation which forms a part of contract of sale and affects the contract is called a stipulation. However, every stipulation is not of equal importance. Okay, so many statements and so many stipulations are made in a contract, but not all stipulations are relevant. Okay, not all stipulations and statements are relevant. Okay, we are talking about major stipulations and major uh, issues which are really going to induce a buyer to buy something. Okay, There may be 10 statements regarding a car, Honda City, but 3 or 4 major statements are such which are drawing all the buyers to buy this particular car. So these 4 statements assume a greater significance, a greater importance in relevance to other 6 statements which are not bringing the customer to their doorstep. Okay, and these are called stipulations or statements. Now, what is a condition and warranty? Okay, what is a condition and warranty? As per section 12 defines conditions and warranty. Section 12 says a stipulation. What is a stipulation now? We know the stipulation is statements or representations which form part of the contract. Okay. A stipulation in a contract of sale with reference to goods which are the subject thereof may be a condition or warranty. Now, the stipulation which is made in the contract, it may either be a condition or it may either be a warranty. Okay, either may be a condition, either may be a warranty. It will depend upon the context of the statement, it will depend upon the substance or the language of the stipulation that will help us in determining whether this is actually a condition or is it a, or whether it is a warranty. Okay, now let us read what is a condition. A condition is a stipulation essential to the main purpose of the contract, the breach of which gives right to treat the contract as repudiated. Repudiated means broken or breach. Repudiated means breach, break. Okay, non-performance. These are the stipulations. These are the conditions. Okay. So a condition is a stipulation essential to the main purpose. A condition is essential to the main purpose. To main purpose. Okay. Main purpose. Like, let us take a discuss about a phone, an iPhone. Okay. They say, Apple says it comes with a bionic chip and is a super fast processor. Is a super fast processor. Now that is a stipulation with the main purpose of the phone. We are buying a smartphone. We want a smartphone which is super fast as well as has a technology known as biochip. Okay, bionic chip. Okay, so we want this particular thing. Suppose now an Apple is shipped to me. Company supplies sells me a phone which does not have a bionic chip or it has a very slow processor. Then it is a condition, it will be treated as a condition, and the breach of this will be a breach of contract or the non-performance of the contract. Okay, non-performance of the contract because it is conditional. This condition is essential for the main purpose. What is the main purpose of a smartphone nowadays? Smartphones are not no longer just for use for making and receiving calls. No, they have multi-purpose and mostly they are used for accessing internet and internet related facilities and so many applications on the internet. So processor plays a very crucial role in choice of a phone. Okay, so when I buy a phone which has a very slow processor but it is claimed that it has a bionic chip and it has a very fast super fast processor, but it doesn't have that, then the stipulation is essential to main purpose and it has been broken, it becomes a breach of it becomes a breach of condition. Okay, so the contract is treated as repudiated or breach of contract has happened or break in the contract or the non-performance of contract. On the other hand, what is a warranty? On the other hand, what is a warranty? A warranty is a stipulation collateral to main purpose of the contract, the breach of which gives rise to a claim for damages. Claim for damages, but not to a right. to. Okay, now there is a warranty. A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to claim for damages, but not a right to reject the goods and treat the contract as repudiated. Okay, now what may be a warranty and what may be condition in relation to iPhone? Let's again get back to the iPhone. Now, iPhone says. Now, iPhone says it has the best camera in the world. Okay, but that is a collateral purpose. Camera for a phone, smartphone, is a collateral purpose. Okay, it is a collateral purpose. It is a side purpose. It is not a main purpose. People do not buy phones for using it as a high definition camera. Yes, camera do come nowadays in the phone, and it has become an indispensable part of any phone. Okay, but they do not come as a camera only. They are phone, and their basic purpose is to be used as a phone and to be used as a smartphone for these things only. Okay, super fast processor and all. If its camera is not the best in the world, okay, they claim that they have a best camera, but they do not have a best camera. So this is a breach of warranty. It is not a breach of condition, it is a breach of warranty. Why? Because it is not attached to the main purpose. Or they say, Apple say, phone has a fast charging, okay, but it does not have it. Ultimately, it has a slow charging. Then it is again a breach of warranty and not a condition. It is a breach of warranty and not a condition, because it is not very much essential to the main purpose. It is not essential to the main purpose. Okay, so these are the situations. Now, when there is a breach of warranty, you can treat the contract as broken. Okay, and you have a right to refund. You have a right to refund. Here you have a. Okay, return the product, but here no right to refund. When there is a breach of warranty, then there is no right to refund. Only thing you get is right to seek compensation. Okay, but you cannot seek refund and you cannot return the product. You'll have to keep the product and you'll have to seek compensation only. Okay, you have to seek compensation alone, because it's a breach of warranty and not a breach of condition. Condition has a more strong purpose in the law than warranty. Condition is given a high pedestal in hierarchy than a warranty. Whether a stipulation in a contract of sale is a condition or a warranty, it depends on each case on the construction of the contract. It will depend now whether it is a stipulation or whether the stipulation is a warranty or a condition. It depends on case to case basis. Suppose some company may come as a camera phone. A company may claim a phone as camera phone, which has best camera in world, or let's say not best camera in world, which has a camera capable of taking 256 MB pictures. ठीक है, 256 MB pictures. Now this particular phone is sold only because of its camera. Okay, now this phone is going to sell only for its camera because it's a new company, nobody knows the brand, but camera, 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 everywhere they are stating about camera. So people are buying this phone just because to use it as a phone as well as a camera. So now when this camera fails to deliver 256 MB or whatever MB pictures, then it will be stipulated as a condition and you will get a right to refund, and you can return the product because it's a breach of condition here. Okay, but if we go in the same manner to the iPhone, here they are claiming best camera, but people are not buying iPhone for camera. People are buying iPhone for, I mean, most of the people are buying iPhone for use it as a phone, as well as a smartphone, which is very secure to use and has a fast processor. Okay, camera is a secondary thing here, but in this particular case, this camera becomes a primary thing. Okay, this is the basic thing why people are buying this phone. So breach of the camera conditions here is very serious, and it can definitely give you a right to return the product and seek a refund from the company. Okay. A stipulation may be a condition, though called a warranty in the contract. Now, in the contract, they may say that these are the warranties. We warranty you about the camera. Okay, and tomorrow when your camera is not working, they want to treat this camera as a warranty only, but it may be a condition. We are not, law is not bound by what is written in the contract. Court is never bound by what is written in the contract. Court works upon its own conscience, upon its own law, and upon its own reasoning. If on the reasoning of the court it comes out that definitely this particular stipulation should have rather been mentioned as a condition than warranty, and the company is trying to dupe people by claiming this condition as a warranty, then court can say that this particular stipulation will be treated as condition though it is written as a warranty. Okay, depending upon the case to case basis. Now let's do an example. Ram consults Shyam. Okay, Shyam, a motor car dealer for a car suitable for touring purposes to promote the sale of his product. Okay, Shyam suggests Maruti and Ram accordingly buys it from Shyam. Okay, now Shyam suggests Maruti. The car turns out to be unfit for touring purposes. Here, the term that the car should be suitable for touring purpose is a condition of the product. It is so vital that its non fulfillment defeats the very purpose for which Ram purchased the car. Ram is therefore entitled to reject the car and have refund of the price. Okay, because Ram wanted a car for touring purpose. Okay, now Maruti is a good car. No issues with Maruti. Maruti is a great company. It's selling highest number of volumes of vehicles every year. Okay, number one best seller in the country. But definitely Maruti is not known for its build quality as well as its touring durability. Okay, so when Maruti is not known for touring durability and Shyam, a motor car dealer, suggests him a Maruti car, then in this case there is a breach of condition. This is a breach of condition, and now Ram can definitely send the car back and seek a refund. Now let us understand this example in a bit different manner. Now Ram went to Sham and said, now he says, I want a family car for city commute and occasional touring. Now the Sham again suggests him Maruti. Now he goes on occasional tours and he doesn't find Maruti capable enough for touring cars. Now he files a case against Sham. In this case, because his purpose was not tourism. Okay, his basic purpose is a family car for city commute. For city commute, his family of five people can comfortably sit in the Maruti and it can easily drive you, take you around the city with no issues at all. But and as a tourist vehicle, it is not well recommended vehicle. But he mentioned occasional touring. So when occasional touring he is doing with the car, then the touring is not the main purpose, and the breach of this particular stipulation will amount to breach of warranty in this case. Okay, not breach of a condition. So it all depends upon the case to case basis. A stipulation which though appears as a warranty may ultimately be a condition, or a stipulation which appears as a condition may ultimately be a warranty. Let us assume Ram buys a new Maruti car from the showroom and the car is guaranteed against any manufacturing defect under normal usage for a period of 1 year from the date of original purchase. Now, what is the guarantee here? Guarantees against manufacturing defect under normal usage for a period of 1 year, okay? And in the event of any manufacturing defect, there is a warranty for replacement of the defective part if it cannot be properly repaired. After 6 months, Ram finds that the horn of the car is not working. Here, in this case, he cannot terminate the contract. The manufacturer can get it repaired or replaced with a new horn. Ram gets a right to claim for damages, if any, suffered by him, but not the right to repudiation. Okay, he cannot repudiate the contract. He can only get the horn replaced. He can only get the horn replaced. He cannot repudiate the contract because horn is a collateral. Okay, horn is a collateral to the main purpose. What is the main purpose? Main purpose is driving around. Okay, and horn is required for ease of driving and safe driving. So it's a collateral. It's not the main purpose. It's a collateral. It's a side purpose. Okay, it's a purpose which comes along, which tags along with the main purpose. So now here it's a breach of warranty. It's a breach of warranty, not a breach of condition. So he'll not get a refund here. Rather, he can only seek compensation. Now, difference between a condition and warranty. Let us now do a difference between conditions and warranties. What is the difference between conditions and warranties? Now, point of difference is meaning. What is the meaning of a condition? A condition is essential to the main purpose of the contract. A condition is essential to the main purpose of contract. Okay. Now, ship. I want a ship for catching fish. So my ship should be large enough or capable enough as per my understanding which should carry fish. But he has given me a motorboat. Okay, he has given me motorboat. No, this won't work. Okay, I want a ship. Condition is essential to the main purpose of the contract. Warranty, it is only collateral to the main purpose of the contract. It is only collateral to the main purpose of the contract. Or let's understand it in a better way. I want a mountain cycle. I want a cycle which is rugged, which is tough, which I can use for. I am a mountains biker, okay, which I can use for go to biking in mountains. That cycle I want, and he has given me a regular cycle. Regular cycle is good for city commute. I can use it regularly in city areas, but definitely I cannot use it in mountain. That is a breach of condition, not a breach of warranty. Okay, that's a breach of condition, not a breach of warranty. But somehow he sells me, now I go just to buy a cycle. He sells me a cycle and says you can also take it on to mountains as well sometimes. So now when I take it to the mountains, sometimes I do not feel that satisfied. Then it is a breach of warranty, not a breach of condition, because that is not my main purpose. My main purpose is to use my cycle in the city only, not to use it as a vehicle for mountains. Right in case of breach. What are your right in cases of breach? As we have already discussed, in case of a breach of condition, the aggrieved party can repudiate the contract. Repudiation means you can cancel the contract, you can nullify the contract, you can break the contract, okay? Or you can claim damages. Okay, you can cancel the contract or you can claim damages, or you can do both. You can cancel the contract as well as claim damages, okay? And you will definitely get the refund, but you can also claim some compensation over and above that refund. That is when it there is a breach of condition. But in case of warranty, the aggrieved party can claim only damages in case of breach of warranty. In case of breach of warranty, because warranty is not the breach of an essential condition, it is only a breach of a collateral condition. So it does not become very essential part of the contract, without which your contract cannot survive. So it is minor tweaks and twitches in your contract. So in this case, definitely you cannot repudiate the contract, you cannot seek or claim the refund, but only right you have is to the replacement of the particular product which is defective, or to seek compensation, or to seek both of them. Okay, but definitely in a breach of warranty you cannot get a refund, and you cannot reject the product. Conversion of stipulations. A breach of condition may be treated as a breach of warranty. Okay, conversion of stipulations means we are trying to convert stipulations, warranty into condition into warranty. Okay, a breach of condition may be treated as a breach of warranty. In certain cases, your breach of condition may be such a slight breach, or the breach may be of such level that it may be treated as a breach of warranty only. But a breach of warranty can never be treated as a breach of condition. Okay, there is no vice versa here. Only in condition, a condition may be treated as a breach of warranty. Who will treat it as a breach of warranty? The buyer. Buyer can choose to treat the breach of condition as a breach of warranty only, like we discussed in the here, that aggrieved party can repudiate the contract or claim damages. When he is just claiming damages and not repudiating the contract, that means the buyer is treating condition as a breach of warranty. He has an option, okay, because he is on the higher seat, he can definitely come down. But here, a breach of warranty cannot be treated as a breach of condition. Okay, a breach of warranty cannot be treated as a breach of condition. Why? Because he is sitting on a lower pedestal and now he cannot go to the higher seat. He is not allowed to do so. He can come down. A buyer can choose to come down. A buyer can choose to not use his right. A buyer can choose not to use his right, but here a buyer cannot choose to use the right not granted by the law. Law grants this person a right to choose that as a condition. He can claim it as a warranty, but law does not give here any right to choose it as a condition, so he cannot do so. When condition is to be treated as a warranty, like we discussed in the conversion of stipulations given in the tabular form here, that a breach of condition may be treated as a breach of warranty. Now we'll discuss about situations in which condition can be treated as a warranty. Where a contract of sale is subject to any condition to be fulfilled by the seller. Okay, the buyer may waive the condition. The buyer may waive the condition. May waive the condition. Waiving means let go, or forget, or not use. Okay, it is upon buyer. Buyer will decide. So, where a contract of sale is subject to any condition to be fulfilled by seller, the buyer may waive the condition or elect to treat the breach of condition as a breach of warranty. It is dependent upon the buyer. If he wishes to treat the breach of condition as a warranty, he could do so, and not as a ground for treating the contract as repudiated. Okay, and then when he'll treat the condition as a warranty, then he'll not get a right to claim the contract as repudiated. He'll not get the right to reject the product. He'll not get the right to seek a refund. Where a contract of sale is not severable means separable, you cannot separate it. Okay, not separable. Where a contract of sale is not severable or separable and the buyer has accepted the goods or part thereof, the breach of any condition to be fulfilled by the seller can only be treated as a breach of warranty and not as a ground for rejecting the goods and treating the contract as repudiated unless there is a term of the contract express or implied to that effect. Okay, now it says, though there is a warranty, there is a condition, but your contract is such that it cannot be separated. Okay, it cannot be separated, and now you have bought a car, Maruti car for touring purpose. Now, can you separate the Maruti from its engine and its body and its tires? No, you cannot do so. Maruti is selling as a one product. My car sells as a one unit, single unit, assembled unit. So it is not separable, but still you have used the car. You have gone on the touring. Okay, you have gone to the touring, and you discovered that Maruti is not a fit car to be used for touring purpose, but still do not complain, and for next 6 to 7 months you keep on using the car. That means you have accepted the good. Once you have accepted the good, now you cannot claim a breach of condition. You cannot reject the product because you have now used it. Okay, you have now used it further. That means you have waived off your right to treat it as a breach of condition. Now what you can do is only you can treat it as a breach of warranty and seek compensation for breach of warranty in the like manner as provided by the law, and you will be compensated adequately. But definitely you cannot claim it as a breach of condition because now you have used it for sufficient period of time even after discovering that this there is a breach of condition. Nothing in this section shall affect the case of any condition or warranty, fulfillment of which is excused by law by reason of impossibility or otherwise. Okay. Now it says that nothing in this case shall affect the case of any condition or warranty fulfillment which is excused by law. Now there is a condition. Okay. Now I buy a drone camera. Now I buy a drone camera. Okay. The seller. Okay. Seller supplies me an expensive model which can go up to 80 meters of height. Okay. Now when I go to take it to 80 meters of height, law says you cannot fly drones above 30 meters. Okay. So now, though the product goes about 30 meters, but law does not permit me to do so, so I cannot treat it as a breach of condition. I cannot treat it as a breach of condition. That see, he has given me a model which can go up to 80 meters of height, but law does not permit it to take beyond 30 meters. So he should not have sold me such a product which is not fulfilling the legal requirements. So this is a breach of condition. No, this is not allowed. Very easily we can see in case of a car has a speed of, say, a car like I have a car, it has a speed of usually 220 kilometers per hour. Okay, the company says it can go up to 220 kilometers per hour speed. But what is the speed law of the land? Speed law of the land, maximum speed which I am permissible to drive on any highway in India probably comes out to be 120 km per hour. I am not allowed to drive more than 120 km per hour on a road. Now, can I treat this as a breach of condition or a warranty that they have sold me a car which clocks the highest speed of 220 km per hour? But what is it? What is it used to me? It is of no good use to me because the law does not permit me to do so. They should have rather kept the speed at 120 km per hour and sold the product at a lower price. Now they are cheating me. No, I cannot do so. I cannot do so. Okay, because that is not permitted by the law. There is no fault of their own. They are saying our product will go. If you want to take it to that speed, you take it at your own expense, at your own risk. Okay. Or there is reason of impossibility, something which is impossible. Now I go and buy a Samsung phone. Samsung claims it has Gorilla Glass and will not break upon falling. Okay, but after falling 3 4 times, my phone broke up. Now I go to the company, file a claim that there is a breach of condition, your Gorilla Glass has broken down, but there cannot be any case in this particular case because this goes against the reason of impossibility. This goes against the law of possibility. Why? Because if you are going to drop something 2 or 3 or 4 times regularly, definitely it is going to break in material of whatever kind of glass is put into it. Okay, so phone are fragile. Yes, definitely it can occasional faults it can definitely sustain, but it cannot sustain faults, so many faults that it becomes impossible for a phone to claim this Gorilla Glass function. So, in this case, Samsung is excused by reason of impossibility. Okay, because it is impossible for a phone to sustain so many faults at one go. Analysis. Section 13 specifies cases where a breach of condition be treated as a breach of warranty. Okay, when condition can be treated as a warranty, but definitely warranty can never be condition treated as a breach of condition. As a result of which the buyer loses his right to rescind the contract and claim damages only. Okay, we are talking about conditions, situations in which though there is a breach of condition, but it will automatically become a breach of warranty, meaning thereby that the buyer will lose his right to reject the product and he'll lose his right to seek a full refund. He can only claim the damages and he has to now keep the product with him. He cannot reject the product at all. In the following cases, the contract is not avoided even on account of breach of condition. Okay, in these following cases, the contract cannot be avoided even on account of breach of condition. Despite there is a breach of condition, then also you cannot avoid the contract. What are the conditions? What are the situations? These are the following situations. Okay, we'll do them. where the buyer altogether waives the performance of the condition a party may for his own benefit waive a stipulation. Okay, where a buyer altogether waives the performance. Now it is upon the buyer to exercise his right. It's just like it's up to okay, it's up to buyer to claim a refund or feel okay with the product. No one can compel him to make a decision. He'll himself make a decision. So tomorrow, if the buyer makes a decision that I'm happy with the product, okay, there is a breach of condition, but I still do not want to return the product. I'll keep it. I love the product, but definitely I'll seek compensation for this breach of condition, which now he'll treat it as a breach of warranty. Okay, now it is up to his own choice. Consumer can waive off this right. Okay, where the buyer elects to treat the breach of condition as one of a warranty, that is to say, he may claim only damages instead of repudiating the contract. Okay, now in this case, he is waiving the condition altogether. In the above case, he has waived the condition altogether that this condition does not matter to me at all. Okay, he waives the stipulation altogether. But in the later case, he may choose to treat this stipulation as warranty rather than as condition. It is up to him. A agrees to, let's do an example. A agrees to supply 10 bags of first quality sugar at 625 per bag, but supplies only second quality sugar, the price of which is 600 rupees per bag. Now there is a breach of condition. Okay, now this is a breach of condition because this sugar has to be of first quality. Okay, but he has supplied of second quality. It's not about price, it's about the quality. Okay, there is a breach of condition and the buyer can reject the goods. Now the buyer has a choice. He can send the goods back and claim a refund. He can send the goods back and claim a refund. But if the buyer so elects, okay, but if the buyer so chooses, he may treat it as a breach of warranty. Okay, he may treat it as merely as a breach of warranty. Okay, and accept the second quality sugar and claim damages at 25 rupees per bag. That's it. Where the contract is non-severable or non-separable and the buyer has accepted either the whole goods or any part thereof. Acceptance means acceptance as envisaged in section 72 of the Indian Contract Act. Okay. Now we are discussing a situation in which buyer has accepted the good or the part of the good and the contract is non-separable, then it will be considered only as a breach of warranty rather than a breach of condition rather than a breach of condition. Okay, he buys a Honda car for racing purposes, but he found out that engine is not powerful enough. Engine is not powerful enough. Okay, though it can race, but engine is not powerful enough. Now, but he likes the car, so he wants to keep the car. So if in case he wants to keep the car, he'll have to keep the car as a whole because this contract is non-severable. It cannot be the case that he'll say no, I'll keep the body, you take the engine. Okay, you take the engine, I'll keep the body. No, that can't be done. If he want to return the car, he has to return the car as a whole unit. If he wants to keep the car, he'll have to keep the car as a whole unit. So in case if he wants to keep the car, then he only claim compensation. He cannot repudiate the contract because the contract is non-separable and the consumer has accepted the goods. Where the fulfillment of any condition or warranty is excused by reason of impossibility or otherwise. Where the fulfillment of any condition or warranty is excused by law by reason of impossibility. Okay, like we have discussed that either it is prohibited by the law, okay, or it is impossible, or it is impossible. Now we go to waiver of conditions. In what situations conditions could be waived? Okay, in what situations your conditions could be waived? Waiver of condition means either you let go the conditions as a whole, or you'll treat the condition as warranty. Waives the performance of the contract, elect to treat the condition as a warranty. In this case, this is a voluntary waiver. We are discussing in a nutshell what we have discussed above. Okay, there are two kinds of waiver of the conditions: voluntary waiver and a compulsory waiver. Voluntary waiver, when it will happen, when he waives the performance of the contract, he himself says it's okay, I do not wish this condition to be performed. It's okay if this condition is not fulfilled. I have no issues. I am okay. I'm happy with the product. So now he has waived the performance of contract. He has himself done so. Okay, he has himself waived the performance of contract, or he elects to treat condition as a warranty. We have discussed he may choose to treat this condition as a breach of condition or a breach of warranty, whatever he feels like. It is up to his choice. No one can compel him to exercise his right in a particular manner. Okay. Compulsory waiver. Okay, compulsory waiver happens in two cases: when non-severability of the contract we have discussed. He says, I am not satisfied with the engine, but I like the car. Now, what to be done? If he wants to keep the car, he'll have to keep the car as a whole. If he wants to return the car, he'll have to return the car as a whole. It cannot be the case that engine is removed from the car and given to the company and claimed refund for that, and car is taken away, car is used. Okay, he cannot say that you deduct the engine's price and pay it back to me, I'll get some other engine in this car, I like the body. Okay, no, this cannot be done. Okay. Or fulfillment of conditions excused by law. Certain conditions which are not to be performed and are not allowed by the law, banned by the law, they are not allowed by the law. So those conditions you cannot file a case upon. Okay, you cannot file a case upon. Express and implied conditions and warranty. Now we'll do what kind of conditions and warranties are there. What kind of conditions and warranties are there? Conditions and warranties may be either express or implied. Condition and warranty may be either express or implied. Okay. Now, they are expressed when the terms of contract expressly state them. They are implied when not being expressly provided for. Okay. Now we have done this. We have done this thing in detail in the Indian Contract Act, that the terms of contract can be expressed as well as implied. Okay, you can enter into a contract expressly by writing or by orally saying, asking someone. Okay, then it will be called express. That means you are speaking or asking for that thing. But you may also do it by conduct. There may be implied contract as well. So similarly, when there can be implied contract, there can be implied warranties and conditions as well. Okay. Express conditions are those which are agreed upon between the parties at the time of contract and are expressly provided in the contract. When we started with this particular chapter, with this particular lecture, it was mentioned that there are so many toll claims made by the company or the seller, but usually they do not form part of the contract, they do not come out in writing. So when they do not come out in writing, they do not hold much water, they are not much valuable, they do not give you any good right. Okay, only those conditions which are written can be used in the law. So express conditions are the most powerful way to go to the court. Okay, so express conditions are those which are written, not only spoken or orally told to someone, but they are also written conditions. The implied conditions, on the other hand, are those which are presumed by law to be present in the contract. Now, there is a new thing, there is a new picture. Implied conditions. Okay, implied conditions in this case are not those conditions which you are doing by your actions or your conduct. No, but law says that certain conditions which law says that we will believe that they are prevalent in every contract. Okay, whether you write it or not. Okay, law will deem means law will assume that these conditions are part of your contract, whether you have written them or not, discussed them or not, whether even a buyer is aware of or not about those conditions, but law will presume that those conditions are a part of any contract of sale of goods. Okay. It should be noted that an implied condition may be negated or waived by an express agreement. Okay, but an implied condition may be negated or waived by an express agreement. If the two people come together and say, no, I do not wish to claim this implied warranty, implied condition, then definitely it can be waived. Okay. Now, what are implied conditions? We will do in the next chapter. Okay, because they are quite detailed and this chapter is about to close. There are only 2 3 minutes left in this chapter, so I do not wish to start those implied conditions right now. Let's have a quick look at the chapter. We discussed conditions and warranties. Okay, and then we went to what are condition and warranty and how to determine what is a condition and what is a warranty. Okay. Then we discuss the difference between condition and a warranty, three types of difference, meaning right in case of breach and conversion of stipulation. Then we discussed when a condition to be treated as a warranty. There are 3 4 situations in which conditions can be treated as a warranty. Roughly, we can summarize it as two types of condition in which voluntary waiver may happen and two types of condition in which compulsory waiver may happen. These were discussed. We were discussing about express conditions which are written in the contract. But now in the coming chapter we'll discuss about the implied conditions which law presume that every contract of sale has them, though they are not there, they are not written, but law will presume that every contract incorporates those conditions as part of the contract.